you. All rise. Court's now in session. The Honorable Judge Tanja Alexander presiding. Give me the key.
Today is today is Thursday, September 16th, 2021. The time is 4:02 p.m. We're here for a bond hearing for Richard Alexander Murdaugh. I see that we have representation from the Attorney General's office. Could you please state your name for the record, please?
Yes, good afternoon, Your Honor. My name is Craig Waters with the South Carolina Attorney General's office, and with me is Megan Bergstedt, also with that office.
Thank you. And also, let's see, the defendant also has representation. Please state your name, please, for the record.
Yes, Your Honor. May I remove my mask to address the court?
Just to state your name, you have to put it back on after that.
Yes, ma'am. I'm Dick Harpootlian. This is Jim Griffin. We represent Mr. Murdaugh.
Thank you.
Thank you.
All right. The cases that we have before us today, Mr. Murdaugh, is case number 2021-8251-01-00204, insurance, false statement misrepresentation, and case number 2021-82510100206, conspiracy, and case number 2021-82510100207, filing for a false police report of a felony violation. Okay? I'm going to read this information to you. It should be in front of you right now. Please follow along with me as I read it. We're going to start with number 2. Warrant for arrest will be issued violation for any condition of bail by order. You have the right and obligation to be present at trial, and that trial may proceed in your absence if you fail to attend. Failure to appear in court as required may result in institution of additional criminal charges. Failure to appear in connection with a felony or while waiting sentence after conviction carries additional penalty for not more than $5,000 of imprisonment for not more than 5 years or both. Failure to appear in connection with a charge for a misdemeanor, for which the maximum possible sentence is at least 1 year, carries additional penalty of not more than $1,000 of imprisonment for not more than 1 year or both. Failure to appear in court as required on any charge not specified above will result in issuance of a warrant to defendant's arrest as well as loss of post bond. You also have a right to a preliminary hearing. You have 10 days from the day to do so. You can do that orally or in writing. You also have the right to a trial by jury. Once again, you're being charged with false statement, misimprisonment, first offense, conspiracy, and filing a false police report of a felony violation. You also have the right to counsel and the right to a court-appointed counsel if financially able to employ counsel. Turn to the next page, please. If you're interested in a court-appointed attorney, which I see you do have an attorney with you now, so we don't have to go over that, but you can, if you want to, get one appointed through the clerk court office. Number 7, if the charge has been brought against you or discharged, dismissed, or no cross, or if you're found not guilty, you may have your record expunged. You're also required to keep the court notified of any changes of address until final disposition of this case. Turn to the next page. This is the notice for right to a preliminary hearing. This is what I was telling you about earlier. If you're interested in a preliminary hearing, you must fill this out and have it back to our office. The next page, information regarding your rights. Please listen carefully. You have been charged with a criminal offense, and if you're found guilty, you're facing serious consequences, which may include the payment of a fine, loss of your driver's license, and a possibility of a jail sentence. In addition, you may face increased penalties for later convictions, the loss of the right to possess firearms and ammunition, and your immigration status will be affected. You have important constitutional rights, including the right to representation by an attorney, but you may lose these rights or waive them if you do not act to protect these rights. You have the right to hire an attorney to represent you in every case. If you cannot afford an attorney, you may be eligible for a free attorney. If you want the determination made to whether you qualify for a free lawyer, then it is your obligation to be screened at the location identified in paragraph 5C of the bond checklist you receive after this hearing. If you do not hire an attorney or go to be screened, then you may be found to have waived your right to have an attorney at your trial. You also have the right to represent yourself. However, you should be aware that self-representation can be dangerous. For example, there will be certain factual or legal defense to your charge that you're not aware of, or legal issues related to conduct of trial or guilty plea that are determined how to preserve an appeal. If you exercise your right to proceed without a lawyer, then you're responsible for complying with all applicable rules of court, including rules of evidence, procedure rules, and proper hearing for the judge and or jury. If you're convicted of the charges filed against you and you ought to pay a fine, you may request a reasonable schedule payment plan to pay that fine. It is your obligation to keep up with your trial date and to obtain an attorney, either by hiring one or by being screened and found eligible for a court-appointed attorney prior to your trial date. If you do not appear at your trial with an attorney, you may be deemed to have waived your right to have an attorney represent you. You are required to keep the court notified of any change of address until completion of this case. Turn to the next page. In the event you are unable to employ counsel, the state will provide you with counsel by appointment or with the service of a defender of this county. If you desire the state to provide you with counsel, you may make application for counsel unless you're not eligible under the order of the court. You may apply for counsel, should you qualify, at the clerical office in Hampton County, located in the courthouse. Once again, to $4 application fee. You do have the right to apply if you meet the requirements, and also you have the right to be present at trial, but if you're not there, they will proceed in your absence. Turn to the next page. You are hereby ordered to appear for roll call on October the 25th, 2021 at 2 p.m. I acknowledge and understand that I'm to appear for and attend the above scheduled roster meeting. Also understand it is my responsibility and condition of my bond that I hire an attorney or apply for a public defender within 15 days of this order. Should I fail to appear for roll call, a bench won't be issued for my arrest. If I fail to get an attorney within 15 days, my bond may be revoked. Understand there is a fee to pay the clerical office for a public defender application, and that is my responsibility to pay the fee within 15 days of this notice. Understand that should I fail to meet any condition of my bond, the court will issue a bench warrant for my arrest and has the authority to revoke my bond. Before I set Mr. Murdaugh's bond, do you have anything to say from the Attorney General's office?
Yes, ma'am, Your Honor, thank you. I believe there's a few conditions that we would ask for that the defense would probably not object to. The first one of those is surrendering the passport. I believe they have brought his passport here. We would ask it be surrendered to SLED for them to keep it in their custody. The second thing is we would like for a bond requirement that he sign a waiver of extradition. It is my understanding that they plan for Mr. Murdaugh to be returned to a rehab out of state, and for that we would request that waiver of extradition. Finally, I think there's a few matters that we would disagree on. Your Honor, at this time we would request $100,000 surety as well as GPS. Your Honor, the reason for that, he has no prior record. However, while the charges here under the law are not violent, the underlying facts are violent. They indicated it was allegedly an intent to harm oneself, and that makes that person not only a danger to themselves, but that enhances the danger to the community in that regard. And then, B, they also involve conspiracy, and that means working with others for criminal activity. So I think that enhances the danger to the community. Also, since he is going out of state, I think that does raise a concern of a flight risk. He was at one rehab and will be going to a rehab in a different state. And again, he obviously has the resources to pay for these out-of-state inpatient rehab. I think that for that reason, GPS would be appropriate, Your Honor. And again, if after 30 to 60 days, if he has done fine on GPS, I'm sure I can speak with Mr. Harpootley, or he can file whatever motion he wishes to file. but I think in this instance, it was appropriate that we have that GPS. I've seen these type of cases before, and sometimes those who had everything and who are suffering a possible fall from grace are actually more of a concern than a hardened criminal who's been in this situation before. For that reason, we would ask for that surety bond and the GPS.
Ma'am, you wearing my mask on? I speak clearly enough with the mask on to make myself understood. Your Honor, Alec Murdaugh spent his entire life in this county. No prior record. Actually involved in all aspects of this community. And up until this charge, had no blemish on his character whatsoever. He has, and we would concede, has had a significant opioid addiction, which has led him into some financial issues and, there's no question, into this situation where he finds himself charged. Let me make a couple points. First of all, this crime involved his attempt to have himself shot so his son could collect insurance money. The only violence he's ever been involved in is this, which was to have himself executed. So he's not a danger to the community. The only person he's a danger to is himself. He immediately surrendered, immediately went to rehab after this incident. As soon as he got out of the hospital, he was shot in the back of the head. A bullet didn't actually penetrate his skull, went in, there was an entrance and exit wound. He may have had a minor skull fracture and some minor bleeding on the brain. As soon as he was released, he went to detox, and he was there for almost a week before he was ready to go to rehab. Unfortunately, the place he was at did not have a bed, and so we had to find him another bed. In terms of his financial resources, he is, this is being paid for by insurance, not out of his pocket. And I can tell you as a result of the recent events, he is not a man of significant means anymore. Everything he owns is basically leaned up. We would surrender his passport to SLED. I brought it here today. Your Honor, I'd like to hand up to the court a letter. I don't want to publish it, or the location of the rehabilitation facility for obvious reasons. We have tremendous media interest in this, and we certainly don't want them showing up. And I think it explains that the doctor believes he can benefit from this, and he only let him come up here. If he came up this morning, he needs to go back this afternoon to not get kicked out of the facility. 17-15-10, which is the statute governing bond, says he's entitled to a personal cognizance bond unless it's shown he's a danger to the fleet. He has come here today on his own. He did not flee. He did not, once he knew he was charged. He is willing to waive extradition to come back whenever he is needed here. Again, every member of family, his connections are to this county. He's got nowhere to go. We're giving the passport to SLED. He doesn't have the financial means to leave the country, nor will he have a passport to leave the country. Your Honor, he has had a tremendous opioid addiction. The death of his wife and son have put him over the edge in terms of that addiction, and that is why, one of the major reasons he's considering having himself killed. The other thing I would say is this. There's no evidence of danger to the community or evidence that he would flee the jurisdiction to avoid prosecution. And the way these charges came about is that Mr. Griffin and I visited him at the detox facility on Monday of this week. He indicated he wanted to tell the truth. And I think SLED will affirm that they were expecting to show up down there and show him a lineup. They're investigating a drive-by shooting. When he and we decided he should call SLED, we asked them to record the conversation, in which he detailed every element of what he is charged with today, total cooperation, gave them the name, told them about the gun, told them about the knife, and we believe was totally honest and forthright with them. So he himself has put himself in this by what he did to begin with, but is attempting to make amends by being truthful. He wants to cooperate with law enforcement. He's cooperated to the extent he can cooperate, given his current mental and physical condition. And when he gets out of rehab, and by the way, we're more than willing to have the facility required to notify us and/or SWED if he leaves the facility. We can do that, so that if he's not there and hasn't gotten court permission to leave there, he would be in violation of your bond order. Your Honor, as Mr. Waters indicated, he has fallen from grace. It has been a tremendous, but before any of that falling happened, his wife and son were brutally murdered. And that has had an extraordinary effect on him. So we'd ask you to allow him to go and help heal himself. A surety bond is not needed in this case, and as a practical matter, his financial condition is ruinous. So we'd ask you to allow him out on his own recognizance. 17-15-10 would indicate and allow him to go to rehab, and of course mandate the rehab facility notify the court and/or SWED if he leaves, and if he completes his treatment there. When he completes his treatment there, we'd ask them to notify us, so we then can coordinate with SWED and the Attorney General's office on where he's to go next, whether he should come back here or whether he should go somewhere else. But this is a 20-year addiction. This is something he's struggling with every day. And if anyone wants to see the face of what opioid addiction does, you're looking at it. This is a horrible, horrible disease. So, Your Honor, I'd be happy to answer any questions if you have any questions. Thank you, Your Honor.
After hearing both sides, I don't feel that Mr. Murdaugh is going to be a risk to the community. I do, however, do want him to surrender his passport, and the waiver of extradition will have that in place. So with that being said, with the insurance false statement, misrepresentation, I'm going to set his bond at $10,000, and that's going to be a personal reconnaissance bond. And on the conspiracy, I'm going to set it at $5,000, personal reconnaissance bond, and filing a false police report, $5,000 personal reconnaissance bond. His total bond is going to be $20,000 personal reconnaissance, and that's going to be the order of the court. If he does leave the facility, if he leaves the facility without any permission, your bond will be revoked, and it will be a benchmark for your arrest. Do you understand that? Yes, ma'am. That will be the order of the court. I need to sign this paper.
And you do the same thing you did on those boards and fix his property.
Okay, just fill this in today. Your Honor, I'm at this point handing this passport to SWED for the record.
No, we don't want to. You want to get the running off? Hold it. Try to get it.
Your Honor, so that letter did not become public information. Can we have it back, please? Otherwise, you ask the file to seal. Thank you, Your Honor.
Send you a copy. So what do you see nobody lives?
All that's the judge.
Yes, all that.
Yeah, all of that. His
Okay.
premium package and everything is in
Yeah,
here.
so, but he's not applying for it, and see, he's done that for, okay.
Just didn't see it.
Thank you.
Murdaugh, do you have any questions before you go?
No, man, no.
If there's no further questions, this concludes this bond hearing on September 16, 2021 at 4:22 p.m.
Thank you.
I think we have to go out this one.
Hold on for a second. We need him to sign the conditional waiver, so we need him to sign the waiver. We don't want you to leave the jail. I don't want him to leave the jail until you sign that waiver. So don't go anywhere until that waiver is signed. We're gonna bring it to the back, or bring you back up to sign it.
Yes, ma'am.
Okay?
Back up here to sign.
Or we do it in the back.
Or we can do it in the back, either way. But it's gonna be signed before he leaves. That has to be signed before
They're
he
trying
leaves.
to get it sent digitally again.
Can you email it to the law firm, we'll get it around.
I just talked to the government clerk, she said, which may require.
No sense, okay.
Yeah, it's, with the, I think with all the traffic, it's not confirmed.
Right.
Right.
So,
So we shut down.
Yeah.
so you think it's going to be fine? Should we
Yeah,
wait here for a
out.
minute, or what do you
You
want?
can wait for a second. Let's do this if we have it. You have it?
Not yet, ma'am.
Yeah, you have it.
Yeah, that be for
Have
1
it
minute.
for a second. So we get the waiver.
Trying to get waivers.
Thank you, Judge.
She said she's sending it now. Before?
She waited.
Okay.
He's not comfortable at all. No matter how it's sitting. Well, I will log on to fix some of the problem.
I think, obviously, we asked for a personal cognizance bond. That's what the judge gave him. Under the law, we feel good about that result. He's going back to rehab today. And once he's been through rehab, I think we can move forward with the case.
I noticed he was a little shaky. How is he? How's his state of mind?
Well, his state of mind, not bad, but physically, he's been on opioids for 20 years, and it's tough coming off.
And just to clarify, it sounded like Alex cooperated with authorities in giving him the name of Curtis Smith.
We called them. They didn't know about Curtis Smith. We called them and gave them the entire story, his identity, his phone numbers, all of it. When I say we, he did. We put him on the phone from Detox.
Do you, Alex, have any idea who may have murdered his wife and son?
No.
What's in the process on that? I mean, it obviously,
Sweat. I mean, that's Sweat. That he cooperated with them. The ball's in their court. They're investigating it. I hope they have a suspect.
Yes, I'm sorry,
Is there
you said
any-
something on the Today Show about knowing somebody who might be involved. Are you inclined to share that right now?
No.
Are you
is
still
there any
working on that?
connection between?
Yes.
Any connection between Curtis Smith and the death of Maggie and Paul?
You'll have to ask Sweat.
Who is Curtis to Alex?
Drug dealer.
Drug deal?
Yeah.
Former client too, right?
Long time ago, yeah.
Is that how they met?
Yes,
How long was he drug dealer?
decade or more.
Were there any problems in Maggie and Alex's marriage?
Absolutely none, none. And trust me, I was with them for almost 2 years. I represented Paul with Jim, and saw them not dozens of times, but a bunch, and always affectionate, always courteous, always, I mean, just a picture of a domestic bliss. So no, no problems whatsoever. And if you talk to her friends, you look at the phone records, they talk to each other 5 or 6 times a day. Definitely not.
Who would have a motive to kill a mother and a son?
It's a good question.
Excuse me, Dick. You had mentioned something about Alex's finances being in disarray. Would you care to explain more about that?
No. Anything else?
Sandra, have you spoken with Buster? And if so, how's he holding up?
Buster spoke to him today. He's holding up. I mean, he's obviously distraught over what's going on with his dad, but he's a trooper. He's good.
What state is the rehab facility in?
None of your business. Remember that state? You ever been there? Okay, now, I've got to get to my car, and it is raining.